We're live.
Thank you. All right, good morning. It's March 15th, 2023, and we're taking up S89, an act relating to establishing a forensic facility. And our first witness is Monica White, Commissioner of the Department of Disabilities, Aging, and Independent Living. Otherwise known as Dale or Dial.
Great. So thank you, Senator Sears, and thank you for the invitation to be here, committee. So again, for the record, my name is Monica White, and I'm the Commissioner of the Department of Disabilities, Aging, and Independent Living, also known as DALE, and joined by our General Counsel, Stuart Scher, who I may tag in depending on the where the testimony goes. So yes, here to discuss Act S89, an act relating to establishing a forensic facility. We did submit written testimony on March 3rd, so that is available. And I will start with just a high-level statement that DALE does support S89 to establish a forensic facility in Vermont, which will address a current gap in the system of care as it pertains to persons served under Act 248. Act 248 pertains to the commitment of individuals with an intellectual disability who have been deemed not competent to stand trial by the Criminal Division of the Superior Court, who present danger of harm to others and for whom appropriate custody, care, and habilitation can be provided by the Commissioner of DALE in a designated program. So any program created for an individual pursuant to Act 248 must be approved by the Judiciary to assure that the individual is held in the least restrictive setting, and there is annual judicial review of whether the individual is still in need of custody, care, and rehabilitation. A forensics facility would provide a secure facility for those individuals who present a level of dangerousness that cannot currently be met in an unsecure placement. Excuse me. DALE is required to continually assess the individual's needs and step them down to a less restrictive setting when such a placement is appropriate, and the individual is further entitled to seek judicial review of their placement. Many of the proposed legislative changes in S89 are necessary for DALE to be able to place a person in a forensic facility when a person's risk to the public requires a secure setting and/or are intended to clean up statutory language that has become outdated due to prior revisions. A detailed explanation of those changes is located in the written testimony that we had submitted. DALE is committed to working with the Department of Health on the operation and administration of the forensic facility, and both departments are in agreement on using an MOU to provide a structure for the administration and operation of the forensic facility, as well as establishing criteria that must be considered for admission to the forensic facility. So that's the very high-level overview that I wanted to share with you. Happy to answer any questions. And again, I have Stuart here for any questions specifically about the statutory language.
For my own, do you have any estimate of the numbers that DALE would have for
Sure.
people that would be eligible for this facility, and the duration that they would need it?
Sure. So, so right now we have a caseload of 27 individuals committed under Act 248 presently. That number is variable with people coming in and going off of Act 248. And in terms of duration of stay in a forensic facility, that would be variable depending on the person's clinical need. And again, our top priority would be to assure that the person is served in the least restrictive setting that assures public safety. So it's not really possible to say with certainty what the duration of stay would be, but it would be intended to be as short as possible to assure both public safety and that the person is served in the appropriate clinical setting.
The only, would it be used during a traumatic episode, for example, where the person is acting in a certain way, and then that person gets themselves under control, or the staff there get them under control, or whatever? Is that what I would see as a short-term?
Senator, I apologize. The sound either cut out or there were people
I'm sorry.
loud outside,
Okay.
so I couldn't hear that question. I'm sorry.
The question was, if people are going through an episode or difficulty at a certain time behaviorally, can't be controlled in a particular setting, would they be then into the forensic unit until they could be under control?
So I think I heard the question, and the intent is always to serve individuals in the community when appropriate and safe to do, to serve in the community. I do think that the forensic setting would provide an additional option in the event that a person's level of dangerousness cannot be served in the community setting, and as a potential flexibility that we do not presently have in our system of care. So it could be possible.
Thank you.
Sure.
Any other questions for Commissioner White? Thank you very much.
Thank you.
Stuart, did you have anything specific?
I do have a couple of points, Senator, if I could.
Absolutely.
Thank you. So for the record, Stuart Scher, General Counsel for the Department of Disabilities, Aging, and Independent Living, also known as DAIL. So, Senator, the only point that I would want to make is that in the written comments that Senator White submitted to the committee on March 3rd, at the end, we did include some proposed additional changes. So if the committee does not wish for me to go over the content of the memo and the legal rationale for asking or supporting the changes in the bill as drafted, the only other thing that I would ask is that the committee note the comments or proposed language on the last page of the department's memo.
Yeah, it'd probably be a good idea if you did go over them.
Sure, happy to. So so would you like me to simply skip over the comments as to why the department supports the changes in the bill, specifically to the provisions that apply to Act 248, and focus specifically on the additional changes we're asking for?
Mm-hmm.
Okay.
Please.
Sure. So there are a couple of items that we were hoping to ask the committee to address. And the first one would be to 13 VSA section 4823A, which is found on page 14 of draft 1.1. In subsection A, after the phrase Commissioner of Disabilities, Aging, and Independent Living, we would ask that the following language be inserted. It would say, for placement in a designated program in the least restrictive environment consistent with the person's need for custody care and habilitation for an indefinite or a limited period. I noted that in reviewing the draft, the language that's currently in statute regarding the least restrictive setting was inadvertently struck, and we want to make sure that it's very clear that we are bound by placing the individual, and the court is bound by placing the individual in the least restrictive setting. The next suggested change would be to strike from the definition of a person in need of continued custody care and habilitation, which is found in 18 VSA section 839(4), which is on page 16 of draft 1.1, and to strike the word still, which is on line 12. Still poses danger of harm to others. It doesn't make much sense in the department's position to say the defendant still is a person in need of custody care and rehabilitation, because the definition of need for custody care and rehabilitation means they inflicted or attempted to inflict serious bodily injury or some other crime on an individual. So to say that they still have inflicted or intended to inflict serious bodily injury doesn't make sense. But otherwise, we do support that entire definition of a person in need of continued custody care and rehabilitation with the word still struck. In 18 VSA 8845 F, which is on page 20 of 24, on line 12, we would ask that the words shall continue, after the word shall continue, that the phrase in a designated program in a least restrictive environment consistent with the person's need for custody care and rehabilitation for an indefinite or limited period be added for the same reasons that I stated earlier. And then finally adding a subsection, it looks like there's a subsection G, no, I'm sorry, subsection G to 8845 that would read, in determining whether a person is in need of continued custody care and rehabilitation, the court shall consider the degree to which the person has engaged in or complied with the treatment and supervision provided by the commissioner. And that proposed language reflects a factor that is relevant in virtually all judicial reviews, the annual reviews of Act 248 commitments. And the courts, in practice, routinely weigh a person's engagement in treatment when assessing the person's need for further supervision. And such engagement or lack thereof by an individual can arguably be probative of their dangerousness. So with that, I'll take any questions you have.
Are there any questions for Stuart? I think those are minimal, Stuart. Are they agreed to by the Department of Mental Health?
I think we have Karen Barber later on who could speak to that. I don't believe that these are not applicable to the DMH commitment proceedings. So I don't imagine that they would be that the Department of Mental Health would take a position on them. However, I'll defer to Karen Barber on that point. Okay,
well, we do have Karen coming up. Other questions for Stuart? No, thank you very much. Matt Valerio, Defender General, is our next witness.
Morning. Thank you for having me. I didn't know if I was going to get a chance on this bill, but spent a couple of, and just I guess for the record, I'm Matt Valerio, Defender General. Spent a couple of years on the S3 study committee, out of which a bunch of these bills have arisen. And one of the concerns that I have is I'm not so worried with the particular language of the bill as some of the people who would have to implement it would be, but that the matters that were attempted to be taken up in a comprehensive way in the S3 study committee, which, by the way, was a very difficult endeavor with a lot of moving pieces, probably too many people on the committee, and put us in a position where we really couldn't come to any kind of consensus. But I think that on certain issues, there was definite consensus, and one of them was the need for in my view, and I think perhaps legal aid felt differently for other reasons, feeling it might lead to unwanted results, but I think there is a need for a forensic facility. I think that there has been a need for a number of years, ever since Irene wiped out the complex in Waterbury, and we haven't had a facility designated in this way since that time. And so we've had a fractured way of dealing with the population that used to be dealt with there. But I want to pose a question here, and this is a question that I tried to pose a couple of times during the study committee, which is, what do you want the forensic facility to do? And if it is to deal with the very high risk, high need, profoundly mentally ill individual who is a danger to themselves and others, who comes in through the criminal justice system. So they are people who have been charged with murder, or they've committed homicides, or they are, very serious aggravated assaults or sexual assaults or that sort of thing, and they're profoundly mentally ill. That's a handful of people who you're trying to address. If you're trying to deal with the individual who has 150 police contacts and is outside the, your business on Church Street in Burlington, who's repeatedly getting picked up with for incidents of threatening behavior and the like, but nothing adds up to more than disorderly conduct or the occasional simple assault, then you're dealing with potentially, dozens of people, maybe 100, maybe more. And when you're talking, so to me, they're very different types of facilities and different types of interventions that go on when you're dealing with both of those different sorts of populations. And I don't think that my concern is that that fundamental question has not been answered. One type of facility would cost a lot of money because it would require a lot of beds. The other type of facility would still be a lot of money, but a lot less beds and probably much more secure. And to me, that when you're talking about a forensic facility, we all can agree that we need one because we haven't had one in a decade or more. But I think that question has to be answered. What is the population you're attempting to serve by this? And I'm not seeing anything right now that answers that question. I don't see that this bill does anything particularly that's going to change the way we do business, because a lot of it happens after the public defense system is involved in the case, when they come in through the criminal justice system. I would note as well, and this is again where some of these issues are fractured. There's another bill regarding competency, obviously, and sanity that's coming up. I wish these were going to be dealt with in one bill as opposed to however many bills there are going to be. But the whole system of how we get into a forensic facility is of concern. And then the question of who represents. A few years ago, we changed the law so that which made some sense at the time, and it was worth giving it a try. It had legal aid picking up cases after a finding of competency or insanity was made, and there was going to be a hospitalization order or a hearing on hospitalization. From the field, from public defense field, I'm hearing that that is causing some havoc within the criminal justice side of things, as far as our ability to resolve things appropriately for clients. And I thought those issues might be brought up. I know that particularly, I know one in Brattleboro and Senator Hashim's backyard, that has become a concern over a period of time. And I was hoping that some of these bills, and I don't care if it's in this one or if it's in other ones that are coming, that we start to answer some of those questions that are not, this bill, but I think we need to answer some of those questions.
Well, why don't I start by, in my view, I had always intended the bill, at least the forensic facility bill, to be one that deals with the first category you described, not the second. Second is a particular problem in community after community, but it doesn't get solved by what would be a secure institution. It's a much different type of problem, and I understand communities have problems with certain individuals. There's that. I think it was Reno, Nevada, that had $1 million Murphy or something like that. Can't remember the last name, but they found they were spending over $1 million a year just arresting him and putting him in jail or putting him in some other place. And then they decided to invest some money in providing housing and other support services for him, and the problem went away. So they actually saved money and they had less problems as a community with million. I'm going to say it was $1 million Murphy, but I don't know what his last name was. I can't remember. So in my view, that's why I think the least restrictive environment language is important. You're placing people who are truly, have committed very serious crimes, hopefully not minor infractions. I hope that answers the question, but if it's not clear in the bill, we shouldn't make it clear.
Yeah, I thought that's the way that this was going, but I'm mindful of like the testimony and the discussions that we had over those couple of years in the S3 study committee, and in the what gave rise to the S3 study committee to begin with was this exact thing that we were just discussing. I think one of the things that legal aid worries about, and they always talk about this, if you build it, they will come kind of thing that
right.
They've talked about. Well, those are the folks that they're worried about. And I do think that some of the public feels that way too. And I want to try to make sure that we're looking at a different way of dealing with those folks than the criminal justice system.
I agree. I think the majority of this committee would also, or perhaps the entire committee would also agree that it's not a good use of secure facilities that are designed to provide treatment and protection to the community from violent offenders.
So that's what I have for today. I'm looking forward to some of these other bills that are coming up as these sort of issues that were split up out of the S3 study committee do come up. And I'll have a lot more to offer on those at that time.
But we do have a S91 competency bill scheduled for tomorrow.
Right.
Are there any other questions or comments on Matt's testimony? I think we should make sure that the least restrictive environment is as strong as possible to avoid some of the things you mentioned.
Thank you.
Bor Yang is the executive director of the Vermont Human Rights Commission. Thank you for joining us this morning.
Yeah, thank you so much for having me. Thank you for inviting me to testify on S89. For the record, Bor Yang, I am the executive director of the Vermont Human Rights Commission. And I will keep my testimony very brief today, as criminal law and civil commitments are outside of our jurisdiction. But the rights of people with psychiatric disabilities is within our purview. And as you all may know, the Human Rights Commission enforces the anti-discrimination laws in the state, including in places of public accommodations. And in Vermont, places of public accommodations has a very broad definition. It includes not only businesses and schools, but also hospitals and government entities, such as the Department of Mental Health and the Department of Aging and Independent Living. And a future forensic facility would be considered a place of public accommodations as well. I do firmly believe that to mitigate discrimination against people with psychiatric disabilities, we cannot just enforce the anti-discrimination laws. We have to also address the lack of mental health resources in our communities. We saw a case at the Human Rights Commission involving an individual who was stuck in the hospital for a year because not a single nursing home in the state of Vermont would take her, despite efforts of her doctors and her nurses, despite the fact that the various state departments were willing to pay additional money. We saw a man with dementia commit a minor offense and end up in corrections, jailed and segregated for a prolonged period of time because he could not get mental health evaluation soon enough. And we found discrimination in that case. And then unfortunately, the gentleman died. The inadequacy of mental health resources in the community is in fact the cause of many crimes. It is connected to homelessness. It is connected to police use of force. It is connected to discrimination. I'm not sure that this bill gets us any closer to a solution, but that doesn't mean that this isn't an important bill on its own or deserving of moving forward. And it's obvious that this bill is responding to the need to address a gap in the system and public safety concerns. And I will defer to the experts in the room on this front. What I will say is I very much appreciate the language and attention in this bill to ensuring that people with mental illness will be placed in the least restrictive environment. That is not only law, but a fundamental principle of human rights. So I just want to thank you all for taking up this bill, but also encourage you to continue to consider future efforts to build the necessary community resources that we need in Vermont. Thank you very much.
Thank you. Other questions for Boer? Yeah. Any comments? Thank you very much.
Thank you.
Or we're going to move right on to Jared Bianchi, Deputy State's Attorney, Bennington County.
Thank you, Mr. Chairman and honorable members of the committee. I just wanted to start by saying I've been really heartened to hear how much we would like to align ourselves with the testimony that you've heard thus far. I think Defender Valerio, for Yang, and the other folks who testified thus far really hit the nail on the head, that what this committee is doing is important and necessary, but it also needs to be really targeted. And I believe Defender General Valerio was really accurate in saying that we need to make sure that we're focused on the types of cases that really need this and not trying to use this for an overbroad population. And I think that we've been able to provide some proposed language to the committee. We've provided it previously, and I have some testimony that was submitted for the record as well that contains it, that would provide the clarification that we think that the bill needs. So with that in mind, I'll turn to my comments. Thank you for allowing me to testify on this important bill. I will be confining my comments to the circumstances which touch on criminal prosecutions and justice-involved persons. As this committee is aware, justice-involved mental health consumers make up a small percentage of persons who need mental health services. But that small percentage of cases can represent an outsized share of both resource needs and public safety challenges. This bill and its companion legislation, S91, provide an important opportunity to remedy some of the most pressing needs in criminal justice-involved mental health space. Right now, there is no transparent public safety focused process for persons who are not competent or not sane, but for who cannot be in the community. Since I last came before you, we've had an opportunity to review the proposal concerning the use of an interdepartment MOU in lieu of rulemaking. We do urge the committee to decline that proposal We are concerned that to do otherwise would be to create an immediate legal question and would miss an important opportunity for transparency in an otherwise opaque process. First, because the suggested MOU would concern eligibility for state programming, we suggest that rulemaking would actually be required under the Administrative Procedures Act, and I refer to our state Supreme Court's decision in Parker v. Gorsuch. The full citation is on file with the committee now. And in general, that case held that department policy interpreting law or generally applicable to a population is subject to APA rulemaking requirements. Second, but relatedly, those requirements exist because stakeholders are entitled to notice and an opportunity to comment. Transparency and good government require it. States attorneys, the Defender General, legal aid, victims' families, just to name a few, may want an opportunity to know what the proposed criteria are and to comment on them before they are adopted. Third, a true MOU, as opposed to a rule bearing the title of MOU, does not need the imprimatur of the General Assembly. The executive departments can and do enter into them of their own accord. As such, the proposed change would be surplusage at best and an APA carve-out at worst. What we really want to focus on, however, is our proposed amendment to S89. I've reproduced, but won't read it in full here, but it's on file with the committee in our testimony from today as well as the other day. I wanted to highlight that this change concerns only those most serious cases that I believe Defender Valerio was referring to as well, and it creates essentially a 7-factor test to consider placing a person at the forensic facility who is criminal justice involved on the basis of that person's needs as well as those of public safety. This proposal would allow a judge to place only people who are held without bail, which is only life sentences and violent felonies, who are adjudicated not competent or not sane, who do not require inpatient level of care, whose treatment needs can be met properly in the facility, for whom public safety requires that they be held anyway, and who a judge has ordered to the facility, and finally, for whom this option is the least restrictive placement, consistent with their needs and those of public safety. This is a critical change to address an exceedingly small but exceedingly challenging population. I would be remiss if I did not echo the comments of your witness, Kelly Carroll. Ms. Carroll is the mother of Emily Hammond. Emily was killed in broad daylight. A defendant is being prosecuted for her killing. That is especially important here because in that case, the defendant was adjudicated not competent for the time being. There was and is a very real concern that that defendant could simply return home as a result. In that case, we achieved something that was an outlier, but should not have been given the nature of the case. He was transferred to the care of DMH in a secure setting, but his hold without bail order remains in place. This means that when he is ready to be discharged from a DMH facility, he will be returned to DOC custody where a judge, as part of a transparent process, can decide what happens next. This is a necessary option for a very narrow set of very serious cases, and its codification here is the critical difference between this bill having a real impact and not having one. Finally, transparency. This change lets us have that conversation about the most serious cases where victims and their families can be heard instead of being kept in the dark. It gives clear guidelines to judges and allows them to render a decision after hearing all of the relevant evidence. It allows for a balanced approach to treatment and public safety when considering serious violent felony cases. I was able to hear some earlier concerns expressed by previous witnesses. Some of these centered on a case called Olmstead. And just very briefly to address those, Olmstead is a US Supreme Court case that concerns the Americans with Disabilities Act. I dealt with these cases over several years during my prior employment with representing the Agency of Human Services. That case rightly holds that people with disabilities cannot be kept in institutions when they are suitable for a more integrated setting. This amendment that we proposed is consistent with Olmstead. It concerns only people for whom a judge has already determined are unsuitable for the community, and their more integrated setting would therefore be jail. Thus, a person for whom this amendment applied would not be held in a facility on the basis of their disability and could only be placed there if it were the least restrictive option. For all these reasons, we would ask you to include our proposed provision in S89 and S91. And thank you very much for hearing our testimony. I'd be happy to answer any questions.
Well, Jared, you struck on one of the more difficult sections of the bill. I'm looking at section 18, which is the memorandum of understanding. In drafting the bill, both Senator Lyons and I were very concerned about the MOU. And so we put in language requiring some kind of legislative oversight over the MAU. You've come with a different one. The administration itself was very insistent on having the MOU. And if you look at the language that we put in terms of criteria, I'm wondering if that doesn't do what you were trying to accomplish. I realize that your proposal is a little clearer. But again, what you have in front of you in section 18, the memorandum of understanding, is kind of the compromise.
Senator, I don't think it accomplishes that. I think that it doesn't give stakeholders any real security in how this process will occur. The APA provides for rulemaking, but more importantly, without the broader language that we've discussed with respect to Title 13, there'll be no opportunity for the defense attorney on behalf of the individual or the state's attorney's office and through them victims to have any feedback. It doesn't create that closed process whereby a judge is hearing from all these people. It is, I think, a step away from a real opportunity for transparency. But also the unilateral decision-making at DMH, frankly, has created some concerns with respect to how this would occur without that judicial oversight. So, to the extent an MOU is necessary to coordinate the process between the two departments, this body doesn't have to be involved in that process. But if what they're really trying to do is promulgate law, then there's a process for that. That exists in the APA. But our proposal is really separate from that. It's to say that for these most serious cases, the process would be, much as it is now for an order of non-hospitalization or hospitalization, it should be done through the criminal division, and it should allow for those orders to stay in place so that the criminal judge who has that ultimate responsibility can make the decision.
Well, we're fortunate on the agenda that our next witness is Karen Barber with the Department of Mental Health. So I think Karen can comment on the proposal. I appreciate it. Are there other questions for Jared on the proposal? I think this is one of the fundamental differences between what we just heard from testimony from War Yang, Matt Valerio, and now Jared in terms of how to set up the system. So this is going to be a fundamental decision for the committee. No questions? Great. All right. Karen Barber, General Counsel, Department of Mental Health.
Good morning.
Good morning, Karen.
For the record, Karen Barber, General Counsel for the Department of Mental Health. I want to thank you again for taking up this important bill and spending so much time on it. I wanted to do a couple of things in my testimony today. I wanted to address some of the points raised by previous witnesses, as well as touch on a few proposed edits that we have on the current draft. So first, Dale, I do want to make clear that DMH does agree with Dale's proposed edits. As to the Defender General, I do want to acknowledge that that is a question that we struggled with at the forensic work group. What population do we need to address? I will say, this language in this bill is really focused on a small number of beds and prioritizing those who've committed the most serious crimes in line with the state's attorney's language and really trying to take their concerns into consideration with the bill. So I do think that the language in section 18 does address that. That does talk about prioritizing those with the most serious crimes. In terms of the Human Rights Commission, I agree with that it will be a place of a public accommodation, which is why DMH and Dale think that the Olmstead issue is so important here, and I'll touch upon that more. But I did just want to note that. In terms of the state's attorneys, I'll respond to his concerns, but I first wanted to note that I can certainly follow up with him individually to better understand his concerns and think about how we can add language to the MOU that addresses his concerns in a way that he feels more comfortable with. I also just wanted to make a general comment on transparency. I think it's important to remember that we are talking about people who have allegedly committed serious crimes and may be a risk to public safety, but because of their competency or sanity issues, they can't currently be held responsible for their crimes and they can't be in corrections. And if they're receiving treatment, their treatment information is protected by HIPAA and state law. And DMH doesn't have a choice about abiding by HIPAA. It's federal law. And I'd also note that Vermont has a statute on point, 18 VSA 7103, which specifically deals with disclosure of information in these types of cases. So I just wanted to kind of note that the DMH doesn't want to be difficult in these cases, but there are privacy concerns that we need to make sure that we're being cognizant of. So in terms of the rulemaking versus MOU, which is obviously a big point here, I'll address Jared's concerns. First, about rulemaking being required, I think it's important to understand the context of the case that Jared was citing. It's from 2001, and it involved a situation where DOC was attempting to implement a policy that would make prisoners convicted of violent felonies ineligible for furlough until the expiration of their minimum sentences. And the court held a couple things, which I think actually supports this not being required under rulemaking. One, that under the APA, a rule is an agency statement of general applicability, which implements, interprets, or prescribes law or policy. And that general applicability, I think, is the key here. And the court noted that. It said the commissioner has prescribed and implemented a written change in furlough policy that is meant to apply generally to a class of prisoners, not making individualized assessments of each prisoner. And the whole point of the MOU is actually to allow us to do an individualized assessment. And we think that's really important. And that's why that flexibility is needed. This isn't about creating due process for a broad class of people. It's how we think about doing individualized assessments and making clinical and least restrictive determinations. I think you touched on this, Senator Sears, but the no notice and opportunity to be heard piece, we actually think that Section 18 does address that. It requires us to have the draft completed by July 1 and go in front of the committee's joint fiscal and joint justice oversight in October, which does leave several months for individuals to see this document and make any comments or input they would like to give that we can take into consideration. And we do think that is important, that people look at it and have that feedback. And to his final point, I do think, well, it's true, we don't need the General Assembly to pass, to create an MOU. We certainly would not attempt to create any sort of MOU to address this population without following Section 18 and assuring it went through the process. I also just wanted to address one last comment he made kind of at the end that wasn't in his written comments about how this doesn't allow state's attorneys or defense counsel to kind of talk about their position. And I want to remind everyone about how this works, right? So the commissioner makes a determination that we think someone is eligible for this facility. It goes in front of the court and there's a hearing, right? So the court hears from the defense attorney, the court hears from the state's attorney, the court hears from DMH or Dale. So there's a whole discussion about whether or not it is appropriate. So there is a forum within the judiciary to make those decisions, which again is a really important part of the due process piece of this. I also wanted to touch on Olmstead because we, again, don't think that the language is consistent. And I think, we talked about this, but Olmstead was a 1999 U.S. Supreme Court decision that basically held that Americans with disabilities have the right to live in an integrated community setting rather than an institution when appropriate, meaning we need to assure people are served in the least restrictive setting possible. And I appreciated Ms. Yang's comments about how we've really made a point to include that least restrictive language all throughout this bill because we do think it is really important. And it's the custodial commissioners that have the expertise and knowledge to make those decisions because they know the different resources around their states, and based on their education and training, understand the often complicated clinical presentations of the individuals. Just because a judge makes a decision doesn't mean AHS doesn't have responsibility under Olmstead. And I think that's kind of where there's a little bit of disagreement, but I think is a really important point. AHS has spoken to several different states, and none of them allow the court to make the final decision for this exact reason, because it's not the court that holds the liability, it's the commissioners. And so they need to be the ones that can justify their decision. You know, with all due respect to the court, they're not clinicians and they don't have a deep working knowledge of the available resources around the states. And I think this also ties into Ms. Yang's testimony. It's not the judiciary that would be required to go in front of the HRC if someone files a complaint. It's the custodial commissioners. And we, again, need to be able to explain and justify our decision, which is why it needs to be a decision that we've made. Because again, if we don't, it puts us in an untenable position. If we don't seek treatment in a forensic facility, it means we've determined it's not appropriate. But if the court then orders it and there's a suit, I'm not sure how we would defend that. So it's, again, the liability rests with the state regardless of what the court has decided. But I want to echo that, or I want to really stress that we hear the concerns of the state's attorneys and the others, that those who commit serious crimes should be prioritized for admission. And we think that is important. And Section 18 calls for that. We really feel like that's an important part of the MOU. So those are kind of my comments based on other people's comments. So I'm happy to answer any questions. I'll just note two things. One we talked about last time, and I think maybe was just an oversight, which was around the definition section, when I talked about how when someone comes into a definition of a forensic facility, how when someone comes into DMH custody through Title 18, they don't stay in our custody. In Title 18, they move over to Title 18 after 90 days. And so just the commitment pursuant language on its face seems to limit it to a 90-day order. So we just wanted to insert that one word, initially committed pursuant, just to make it really clear. So that's a kind of a minor tweak. And then we did have some tweaks to the MOU language. And I wanted, because it's
Karen, can I stop you right there on the 90-day hold?
Yeah.
I think the committee needs to better understand how that works and how it would work under the new bill and under Section 18. That's one of the fears of the victims community, I think, is that after the 90-day hold, people would get released.
Yeah, absolutely. So that's why the changes to most of the changes in this bill are in Title 18, because so what happens is if someone comes in through Title 13, so there's a competency or sanity issue, the criminal court can issue a commitment order. The language in the statute says for an indeterminate period, but there was a Vermont Supreme Court case that limited that order to 90 days because in the civil context in Title 18, the initial order can only be for 90 days, and then we have to reapply. So it's consistent with that. So basically, it's a due process mechanism, right, to assure that if someone remains in custody after a certain period of time, there's enough clinical evidence and they meet the statutory standard that they remain in our custody. So that's why it's so important that we include language that makes it really clear that it's not just for those 90 days, that when so what happens is, if someone's in our custody under a criminal court order, then we file in family court. So after those before the 90 days are up, we'll file and say we would like to remain, we'd like the person to remain in our custody. So we file in family court, and then the court orders then are in family court. So it's a seamless transition. We do it all the time. It just jurisdiction is just changed over to the family court. Does that answer your question?
I think so.
Okay. Did anyone else have a question on that before I go back to the MOU? Okay. So our goal with the MOU is to deal with how DMH and Dale will administer and operate the program, which includes individualized admission assessments, which is why we've made some of the tweaks that talks about it's about the administration and operation of the forensic facility, because we do think it's more than just admission. We need to think about how we're going to use the beds, how we're going to work together as departments to make these decisions. You know, this is an entirely new level of care and a very small number of beds, and so we really want to make sure we're working together. And I want to again stress that, you know, we heard that state's attorney's concerns. We tried to incorporate their language. One of the additional ways we thought, after hearing Jared's comments, was that we could make it clear in the MOU that one of the procedural steps the custodial commissioner has to take into account when considering admission to the unit is to get the position of the party. So ask the state's attorney and the defender general what their thoughts are on admission. I also just want to kind of note how we see the MOU playing into our applications. So again, the custodial commissioner would make a determination that we thought that placement in this facility is appropriate and least restrictive, but it goes before the court, and the court gets to make the final decision about yes or no. And changes in Section 2 of this bill make amendments to 18 VSA 7612G, which talks about what the application has contained. And just like when we're asking for someone to go to the Middlesex Therapeutic Community Residence, which again is a more restrictive level of care, in that application, we have to detail why we think no least restrictive alternative is available to that person. This does the same for the forensic facility, but we think the plan is to use the criteria in the MOU to really lay out for the court what we've done to make that analysis so that the court can clearly understand the process behind the commissioner's recommendation so that they can really have all the information in deciding whether or not to order it. And so the edits we propose are really tweaks, but they're just more about establishing that this is how the departments work together. This is about individualized assessments, so we want to make sure that there are factors to be considered, but that we can be flexible in terms of, you know, every clinical presentation is different, and so we want to make sure we can account for that. And we really welcome the input, not just from the Joint Fiscal and Joint Justice Oversight Committees, but also stakeholders and members of the public. So in closing, I'm happy to answer any questions, but I just again want to thank the committee for all their work on this. We're talking about a small number of individuals, but really complicated cases that require us to continually assess how to best provide treatment in the least restrictive manner, while also considering public safety concerns. We do agree with both, I think Matt Valerio touched on it, and Jared, that S91 is an important component of all of this. And so we're glad that the committee will be able to hear some testimony on that tomorrow, but happy to answer any questions.
Are there any questions for Karen? Yes, not. Thank you, Karen.
You're welcome.
Our next witness on the agenda is Katie McLinn from Lakes Council, but I don't think she's here.
She is.
Oh, you're here.
She's remote. Yep.
Oh, okay, good.
Good morning.
Good morning. Katie, I don't know if you heard the amendments offered by the state's attorneys and sheriffs, as well as the amendment offered by the Department of Mental Health regarding the memorandum of understanding. So I guess where I'd like to focus is on section 18 right now, and what the committee's options are and how we get through this.
Sure. So I have received DMH's proposed changes. I have not received the state's attorneys, and I was in another committee, so I missed their testimony. I don't know if it would be possible for an electronic version of their edits.
Yeah, actually it's on our webpage. Jared provided a thing. If you want to take 5 minutes, do you want to take 5 minutes and kind of look over that
I
proposal?
came in the middle of Jared Bianchi's testimony. So I heard part of it, and he was referencing the Parker case.
Yeah, why don't you take 5 minutes, because I think this is a critical area of disagreement, if I might add to the bill, and it's one that you and I and Senator Lyons, when we were first drafting the bill, had concerns about. So why don't we take a 5-minute break and come right back? That be okay, Peggy? Come back at 10:01.
Yep.